Alex here with part 97 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to go into part 0, or to remind my viewers to please take a look at part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my reply to my ex's opposition. Oh, wait a minute. This is actually my ex's reply to my opposition to her motion to quash the subpoenas that I issued. So it's probably going to be a continuation into her arguments against having the court take a look at her mental health records. And I don't know much about my mindset. I know I didn't even cover it in my previous video because I feel like throughout this entire process I was dismayed. I just didn't understand why they were going to put so much work into keeping those mental health records away from the judge's eye. In my opinion, he already had taken a look at them anyway, and I felt like, for me to fully understand what's going on, I need to have, a look at those records. But that was then. Now, in hindsight, looking back, I think I know why they did that. My ex's attorney knew that those mental health records were going to be very damaging to her client. And here is the irony in all of it. I thought that my ex's attorney knew that the judge already looked at him, so it wasn't going to be like any kind of shocker for him. But I did a video, this is of course years later after my case was over, called "The Judge Does Not Remember You." And most likely, my ex's attorney knew that the judge would not remember those documents. And I feel like, and I'm not exaggerating at all, 99.9% chance the judge did not remember what was in those documents. And I feel very, very strongly about that percentage. I am not exaggerating. So my ex's attorney knew, I think, that if the judge had seen those records again, he would consider what was going on to be closely related to the mental health diagnoses or findings in those records, and it would probably have resulted in the end of my ex having joint physical custody. And even though I, as a litigant, didn't see what the big deal was, my ex's attorney did, because she remembered that the judge was heavily impacted in the past, and she knew that at this point in time, the judge would not remember what he had looked at. If you guys haven't seen the video, "The Judge Does Not Remember You," please watch that video. So many of the things that lead us down the wrong path when representing ourselves against attorneys are because we have these notions in our head of what's going on that are nowhere near reality. Like a lot of people think, oh, well, their attorneys are going to care about the kids too. They're not going to just do whatever they're... No, they just want to win. If that means facilitating child abuse, they'll do it. It doesn't mean that they're going to be told right in their face, hey, you're facilitating child abuse, but they're just going to assume that their client is the good person, and they're not going to look any further than skin deep. They will represent an abuser and facilitate child abuse. If that means the court puts its own workload over the best interest of the child, that's true too. A lot of times the courts take it out on the person filing too many papers. They don't really care if you're trying to protect your child. All they care about is that you're filing too many papers. And then of course we go, run full circle back to what I said earlier. They don't remember you. They don't remember your case. They don't remember the details. I talk a lot about how little the judge remembers a litigant in that video. Sometimes if you are really annoying, they will remember you in general terms, sort of as the annoying person, but they won't remember any of the intricate details of your case. So all of these things that I know now, I didn't know then. Anyway, I think at this point in time, we should probably just go ahead and take a look at what my ex's attorney has filed. Here we are with my ex's attorney's reply to opposition to motion to quash subpoena duces tecum. This is the standard introductory paragraph where my ex's attorney is indicating that she's representing my ex. She's not really the defendant, she's a respondent, and I'm not really the plaintiff, I'm the petitioner. But this is probably just a copy-pasted document where they just filled in the blanks and they forgot to change these things. By the way, guys, I suspect that a lot of the arguments in this reply are going to be most likely very similar to the arguments in the previous document, which was the opposition to my motion. And I'm not going to cover those again since I already covered them in the previous video. Please watch, if you haven't seen it yet, the previous video in my Docket series so that you can get the actual full details on those arguments. I'll mention, very quickly if they were already covered. So, standard introductory paragraph. She covers, at least under the points and authorities, she covers the subpoena duces tecum that I had issued on October 29th, commanding West Hills Hospital to turn over what she calls confidential records. I'm going to skip over that, guys, because I've already covered that in some of my previous videos. It's not confidential, or the issue is not that it's confidential. The issue is whether or not it is privileged. Those are two different terms. They mean two different things, and it matters. Next paragraph here is the in-camera review, which she's already, I've already gone over this. I'm going to skip over it. The next two paragraphs I've already gone over. Argument, Rule 16.21, which I've already gone over. McMonigal, which I've already gone over. I went in great detail over what I thought about these arguments in those previous videos, so definitely do not skip over them because I talked a lot about these. Conclusion, it's standard. Well, she says I'm trying to backdoor my way into getting my ex's confidential mental. What? It's not the back door, that's the way. She's trying to make it seem like I'm sneaking around the law. No, this is like the front door. This is like the full frontal assault here. There's nothing back door, side door, sneaky about this. This is just the way that it's done. Ask any attorney who goes through discovery. This is how it works. So anyway, let's move on to the next page here. Certificate of service. Here we have, it's just a standard Rule 5 service, which is that the documents were mailed to me. Moving on to the next document, we have my affidavit regarding ghost lawyering. I've been looking forward to this. Number one, I tell the court that I am not using a ghost lawyer, nor am I aided by an attorney, nor am I aided by non-attorneys. Number two, I'm doing my own research of the NRS, NRCP, NRAP, DCRW, DCRWD, FCR, and the SCR. These are all the local rules, and yeah, these are the local rules. Next is the indication that I am researching case law and relevant to all matters, both covered by the court's binding stare decisis. In fact, if you want to know what stare decisis is, please watch my video on it. I'm 99% sure I've done a video on this. And I, of course, am trying to get a better understanding of the opinions of our superior judicial authorities. And the next assertion here is that the cost to obtain counsel is prohibitively expensive, and I must represent myself. And I'm mentioning here that the Supreme Court of Nevada has stated, pursuant to Supreme Court Rule 44, I am allowed to represent myself in any court except the Supreme Court. Ironically, they do allow people to represent themselves in the Supreme Court. The only difference is probably at oral arguments. I don't think they let people represent themselves at oral arguments. I think that's all I was going to mention. Oh yeah, there's also a constitutional right behind this. So even though, like if SCR 44 was gone, I would still have the right to represent myself pursuant to the United States Constitution. By the way, guys, I have a video on this issue, representing yourself. A lot of attorneys and judges say a person who represents themselves is a fool for a client. I hate that statement because it makes people feel like they're stupid when really they're just a victim of not having millions of dollars. How does not having millions of dollars equate to stupidity? It doesn't. And I know some attorneys think that that's an exaggeration. You don't really need that much. You could do it with $5 grand. Yeah, that's not going to get you through a high conflict child custody case. That's like one hearing, maybe 2 filings. High conflict child custody cases go on for years. High conflict child custody cases require hundreds of thousands of dollars to litigate to conclusion. That's the way it works. And so for them to act like, oh no, you just need to, sell your car, take out like 10 grand in debt. That's just a really disingenuous, borderline fraudulent statement, because they have to know that these cases don't end after one hearing. They've been doing this. This is a profession. They're family attorneys. They've seen high conflict cases. They know they last 5, 6, 7, 8, 10. Sometimes they last 18 years, beginning to end. So this isn't a total shocker to those attorneys that you're not going to be able to litigate this case with a couple of grand. You're going to need a lot of money. Anyway, moving on. I understand the perils of self-representation as discussed by the Nevada Supreme Court, and I cite this case here, which recognizes how difficult it is to represent yourself. I'm doing everything in my power to make my pleadings as articulate, logical, and rational as possible. And that looks like the end. I have my Rule 5 Certificate of Service here indicating that I served this upon my ex, looks like personally. Request for submission. And this is a request for submission by my ex's attorney. She is indicating that the motion to quash and the opposition and replies be submitted to the court for consideration. If you want to know more about the request for submission, please watch the video on this topic. Do not skip over that video. I talk about it so many times, and I'm getting sick of it because this is like the 100th time we've seen a request for submission, so I'm going to move on. Certificate of mailing under Rule 5 indicating that this request for submission was mailed to me as well. Going into the aftermath, I filed, looks like one document, but it was a free filing, so I incurred $0 in costs. My ex's attorney filed 2 documents, both were free filings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably very briefly reviewed the affidavit regarding ghost lawyering. She was probably curious to see if an attorney was helping me, and I would go ahead and put that at 5 minutes. The request for submission prepared by her office, it's a standard form document. 5 minutes I think is fair for that, so we're looking at 10 minutes. Then we got the reply to opposition. It looks to me mostly like a copy paste. I can't recall anything at all that was different about that document. Since it was a copy paste, and she probably didn't even have to consult her client. I'm hesitant to say 5 minutes, but it really was, for the most part, the same as everything else she's been filing. So let's go ahead and say 5 minutes. So that comes to 15 minutes in attorney fees for my ex at the rate of $250, comes to $62.50. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.